Hi everyone, Mrs. Thorson again with GOPO. Today we're going to finish talking about the Civil Liberties Unit. We're going to focus on basically the last part of the Bill of Rights. We're going to look at amendments 4 through 9. So let's look at first the rights of the accused or the rights of defendants. We're going to see that in the 4th through the 8th Amendments, but before even those amendments were made, the Constitution did provide some protections to those accused and convicted of crimes. This was in the Articles. We see the ex post facto clause, which said laws criminalizing conduct that was legal at the time it occurred cannot be punished for you cannot be punished for something that was already made. So like let's say, let's look at the smoking law that just got created in 2019, where starting July 1st, if you are 18 years old, and smoking, it's now 21 years old. You have to be 21 to smoke. Well, an ex post facto means that if you were smoking as an 18-year-old in June and then July 1st, you're not smoking anymore, but the age is 21, you can't get in trouble for that now that it's a new law. You can't get in trouble for doing it in the past when it was legal before. Bills of attainder are a law passed by Congress punishing an individual without a trial. You can't do that. So you have to be able to have a trial before, if you are charged with some type of crime. The writ of habeas corpus protects defendants, which is your document setting out the reasons for arrest or detention. So you have to be given a writ of habeas corpus. You can't just be thrown in jail and not told why you're thrown in jail. And then, of course, due process. Due process is just a judicial standard that there's fairness and equality under the law for all people. All people have certain rights under the law, and these things are all part of the Constitution before the Bill of Rights. But when the Bill of Rights was added, we get some amendments that protect it even further. So the Fourth Amendment is the no illegal search and seizure. Searching can be of people and of things, as well as seizure can be of people or things, or taking them. In the case of a seizure of a person, you're arresting them. The government has to obtain a warrant before doing this. So a warrant is an official document issued by a judge authorizing the search of somebody, and if they find it, they can seize you or seize the stuff. But it's got to be very specific. For instance, if cops are looking at your house for a car, they think you stole a car, they have to be very specific where they can look. They would be able to look in the garage or on the property. Obviously, they can't look in drawers for that in a home. So it would be like, we're specifically looking for this item, 2010 Ford Mustang or something that supposedly you stole. Now, to get this warrant, they have to have probable cause, which is some type of suspicion that the crime has been committed, or some type of evidence that shows there can be an investigation with it. But sometimes there have been situations where police have obtained evidence illegally. And when that happens, this was in the Weeks versus United States case, they had to not use that piece of evidence in court. Well, that was a federal case. That was about selling lotto tickets over state lines, and they obtained that information, catching the guy illegally, so they couldn't use that evidence against him. So in the court case of Mapp versus Ohio, a woman there was a warrant out to go into a woman's house to look for a fugitive, but the cops looked into this small trunk type of suitcase and found pornography, which was illegal at the time in Ohio. And she got arrested for the pornography, and she took it to the court, and she's like, listen, you can't arrest me for this. I can't get in trouble for this. I know the Fourth Amendment protects me from illegal search and seizure. You got to help me out. And the court of Ohio is like, we can do whatever we want. This is an Ohio case, not a federal case. So she took it all the way to the Supreme Court, and they're like, yeah, you can't do that at the state level or the national level. It basically says if evidence is obtained without a warrant, it cannot be used in court. Now, the Fourth Amendment's protections, even though we see this, are not absolute. If there's reasonable suspicion, let's say a cop pulls a car over and the person seems drunk, that's reasonable suspicion. They can get arrested. They can get searched without a warrant. Or if it's in plain sight, let's use that same example. Let's say the cop pull someone over for speeding and they look in the car and there's a bag of marijuana on the seat, you obviously don't need to go find a warrant for that. All right, so let's assume you get arrested. We see that there's the Fifth Amendment rights as well. So here's a couple of things. First of all, you do have the right to a grand jury. And a grand jury is not the people that you see sitting in the box in a courtroom on TV with the judge and objection, you're out of order, none of that stuff. A grand jury actually meets before a case to just see if there's enough evidence to even charge someone with a crime. And that's usually done in pretty high profile cases. A more recent example would be the Breonna Taylor case, when they were looking into whether or not the cops should be charged with the crime of murdering Breonna Taylor. It was a grand jury, which anybody can be called for jury duty for, and they decided no, there was not enough evidence to charge the police officers with the murder of Breonna Taylor. So if they did, but like for instance, in a Michael Jackson case, they had a grand jury, and they said there was enough evidence to charge him with child molestation, and that's why he went to court. So those are just the grand juries are the ones that decide if there should even be a case. Now, another protection in the Fifth Amendment is no double jeopardy. You cannot be tried for the same crime twice. So if, like for instance, O.J. Simpson, when he was found not guilty of the murder of Nicole Brown and her boyfriend, if evidence came out today of a videotape showing him murder them, he can't get charged with that. There's no double jeopardy. From the Fifth Amendment, too, was the interpretation of the Miranda versus Arizona case, or the Miranda rights. This is when if you get arrested, the cops tell you have the right to remain silent. You can have an attorney present when being questioned. This goes along with this Fifth Amendment right to no self-incrimination. You don't have to testify against yourself. So that's where kind of the Miranda rights come in. And we're talking at any point from arrest to conviction. You don't have to testify against yourself at any point. The Sixth Amendment, this is the one that says you have a fair, speedy public trial. Speedy trial, the public trial, fair trial is that you have an impartial jury, meaning an unbiased jury, and you can have an attorney present at the trial. So in the case of Gideon versus Wainwright, Clarence Gideon had gotten into a bar fight and in Florida got arrested, and he was told, this is what I told you guys about in section 1. He couldn't have a lawyer because he couldn't afford one. And he said, well, I should be able to have a lawyer. The Sixth Amendment says that. And the court of Florida said, well, the Sixth Amendment's for federal cases. This is a state case. He took it all the way to the Supreme Court, and the Supreme Court said, you know what? You are right. This violates the Sixth Amendment. No matter what level you're at, state or national, you have the right to a lawyer. So he won that appeal. The Eighth Amendment comes to, we're looking at bail and we're looking at punishment. This is the no cruel and unusual punishment and no excessive bail. So bail is the amount of money that you post as like a deposit that allows a defendant to be free during the trial. So if you get, charged for, let's say burglary, you rob someone's house, the bail can't be like $3 million. It's got to fit the crime. And then cruel and unusual punishment, the punishment, if you get convicted, if you get found guilty, has to fit the crime. Again, you can't get the death penalty for robbing a grocery store. Death penalty is only for murder, capital punishments, capital crimes like murder or treason. That being said, each state gets to decide if they want to use the death penalty, and the federal government does have the death penalty. Doesn't use it that often, but they have it. But the death penalty is definitely the one that gets interpreted with the Eighth Amendment. And for about 4 years in the Furman versus Georgia case, they said no death penalty anywhere. It's unconstitutional. And then 4 years later, they're like, yeah, just kidding. It is constitutional. So moral of the story, anybody can use the death penalty. States can decide. Illinois does not have it, where other states like California, Texas, they have it. And they basically said the reason that the Furman versus Georgia just got rid of it point blank was because states were using it in willy-nilly ways and didn't really have a good structure. But then with Gregg versus Georgia, states were like, all right, if we have like an actual structure and a list of directions for the jurists, and like a list of black and white, here's what you can get the death penalty for, here's what you can't. Can we have it? And the Supreme Court in Gregg versus Georgia said yes. So that's when it talks about they had to have certain message or methods of how they use it. All right, the last one I'm going to talk about is the interpretation of the Ninth Amendment with the right to privacy. The Ninth Amendment is the one that says, if we forgot about any other freedoms or liberties that you have them. And this is where the right to privacy has been interpreted. And it first got interpreted with the case of Griswold versus Connecticut. Connecticut had a law prohibiting the use of contraceptives, and they took it to the Supreme Court, and the Supreme Court said that's a private right, so that is protected by the Constitution. So it's implicit, it's implied in the Constitution. It's never explicitly said in the Constitution. But the Ninth Amendment is where they use it the most. But Griswold versus Connecticut was definitely a watershed moment in the Supreme Court, because since they interpreted that to be the right to privacy, we start seeing other cases use that case as precedent for the right to privacy, including the case of Texas or Lawrence versus Texas, where they were fighting to get rid of a Texas law that banned sodomy, because they said, well, that is a private right in the bedroom, and they can do that because of Griswold versus Connecticut saying that we have the right to privacy. And the court used that precedent in Lawrence versus Texas and said, yes, the Texas sodomy law said that same-sex sexual conduct is legal, is constitutional. Abortion is the big one. So abortion with Roe versus Wade, this is one of the 5 most important. I mean, it's one of the 15 you have to know, but in the scheme of things, it's one of the 5 most important cases in American history. It's still an issue today. I mean, it's still a issue. It's been one. It was one then, and it still is now. The court said you do have the right to privacy, but there's still opponents to it. Opponents say it violates deeply held religious beliefs, that terminating a pregnancy is murder. There's also opponents that say those are people, and people are protected under the 14th Amendment. But people who are proponents of the Roe versus Wade decision say women have the right to choose what to do with their own bodies. So here's kind of the background of the Roe versus Wade case. Norma McCorvey was a woman who lived in Texas, and she filed a lawsuit against the district attorney of the county because she wanted an abortion in Texas, and Texas criminalized it. And she wanted to get a legal abortion, but couldn't get one because her life was not in jeopardy, and she could not afford to travel anywhere where it was legal, including the state just north of them. So she took it to the Supreme Court saying, basically, this is violating my right to privacy. And the court agreed with her. She said the Constitution does protect a woman's right to an abortion in the first 3 months of pregnancy due to the right of privacy. So the Ninth Amendment, like I said, the rights really aren't specified, but it does address one main worry about the Bill of Rights, that some rights aren't listed. And the one hands down that has been interpreted the most with the with the implications of the Ninth Amendment is the right to privacy, and that's seen in all the cases I just showed you. All right, so this is it for civil liberties. Next up, we're going to be talking about civil rights. I will talk to you guys later.